All right, perfect. Well, thank you very, very much, everybody, for joining in. It is 4:30 sharp, and we are initiating. A few people are joining in, so let them come in and get settled as well. I'll like to take a moment to thank everybody for sparing their time and an hour and on another web series and a webinar that we are doing at Khurana Khurana, and absolutely a pleasure to welcome two dear friends and colleagues whom we work with on a very regular basis in the European market and now also in the UK separately. And Adrian, who comes from a patent background, and Jonathan, who comes from a trademark perspective. And I think we're at a very pertinent point to be wanting to talk about this topic, where Brexit is sort of just the implementation has just been done, and we want to understand what kind of practical implications it is going to have on entities that have portfolios at the patent office European level and at the registry at the EU IPO, and also then understand how and what are the best practices that sort of should be done at this very moment before it's too late to sort of get the right protection in the UK. So Adrian and Jonathan, very welcome, and absolutely a pleasure to have you both. Thanks for accommodating us early in the morning for you. And please, take a few minutes to tell us about the firm, about your practice, and then we have a defined agenda and we'll go point by point from there.
Wonderful. Well, thank you very much, Taryn. It's a great privilege and opportunity for us to speak to you this afternoon. And we're delighted to do it. I'll just say a few words about Cleveland Scott York and the practice, and then we'll launch into the main event of this afternoon's proceedings. So Cleveland Scott York is a very long established firm in the UK. We advise on all aspects of intellectual property, in particular registered rights, so that's patents and trademarks and designs. We have about 60 people in the firm, all told. About half of those are professionals. And we have also a presence in Europe, in the European Union, in Munich. We advise a lot of domestic clients and a lot of international applicants as well, in particular in the US and in India. So Jonathan and I are very active in Indian market, and we have been regular visitors over the past decade, and have formed friendships with Taryn and his colleagues at Khurana Khurana. So Jonathan, do you want to add anything about the firm, or should we launch in?
I think you've done a great job, Adrian. Let's crack on.
Okay. So the topic of the discussion for this afternoon is Brexit, and in particular, what are the ramifications for intellectual property? So I think it's worth talking a bit about what Brexit actually is. So since the early 70s, the United Kingdom has been a member of the European Union. There was a plebiscite in 1973 to join the European Union. And to remind ourselves, the European Union is a political and economic union of 27 member states that are located primarily in Europe. And the main aspects of EU membership, which are salient for these discussions, is that there is an internal single market, so there is frictionless trade between member states, and a standardized system of laws in areas where member states agree that common lawmaking is desirable. So for almost 50 years, the United Kingdom was a member of the European Union. However, on 23rd of June 2016, there was a referendum in which 52% of the population voted to leave the EU. The UK technically left the EU on the 31st of January 2020, and this allowed a one-year transition period for negotiating a new trade deal with the remaining countries in the EU. And that was successfully concluded at the end of last year. And on the 1st of January 2021, we have had what we call actual Brexit Day, when the legal implications of leaving the European Union come into force. So that's a kind of whistle-stop view of what has been almost 4 years of sometimes agonizing discussion, negotiation, argument, and tears and wailing of gnashing of teeth. But that's all behind us now, and we're looking forward to a bright new future as an independent sovereign nation. So the questions that arise for rights owners like you people in the audience is, how does this affect my intellectual property that is in my portfolio at present, and what implications does this have for my IP strategy going forwards? So there are a number of areas of intellectual property that we're going to touch on in our discussion. So the biggest impact, I think it's fair to say, is on EU trademarks and registered community designs. So these rights were what we call unitary rights. So they were a single right which covers the whole of the European Union. So obviously, when a member state leaves the European Union, that has an effect, and it needs to be decided how that is dealt with. There's also impacts on things like copyright and unregistered design right. We'll talk relatively little about these. EU domain names we will mention. And obviously patents is an area which is potentially affected by Brexit. So we'll turn our attention first to patents. Now, the impact of Brexit on patents is more subtle than in the area, for example, of trademarks. So the European Patent Office, which you are probably familiar with, is not it's not an organ of the European Union. So the UK did not leave the European patent system on 1st of January of this year. So the status quo is maintained. So UK attorneys retain full rights of representation, including at the Board of Appeal. So really, in practical terms, there has been very little change in our practice with regard to the European Patent Office. We still retain our full rights of representation. European patents, once they are granted, can be made effective in the United Kingdom. And really, there are, in terms of obtaining and enforcing patents, there is very little change in our day-to-day practice, which is kind of a relief to UK practitioners. Now, having said that the European Patent Office is not an EU body, there are some aspects of EU law which are implemented in the European Patent Convention, in particular regarding biotechnological inventions. And there's another area which, although it's not part of the European Patent Convention, is an EU regulation. And I'll talk about these later on in the talk. But I think it's worth setting out at the outset that the European patent system, which you know and love, has not changed. The UK is still a full member state, and you can gain patent protection in the United Kingdom via a European patent. So, having set out the headlines for the patent situation, I'll return to that later on, because there are some subtleties in patent law which are affected by Brexit, but I'll talk about those later on. I'll hand over to Jonathan to talk about trademarks.
Well, thank you very much, Adrian. And can I first of all join Adrian in saying it's a real pleasure and a privilege to be speaking to you today. Thank you for the invitation, Taran, and we're very pleased to be here. So I'm one of the trademark partners at Cleveland Scott York, and I'm going to focus now in a little bit more detail on the effects of Brexit on EU trademarks and registered community designs. And as Adrian alluded to a moment ago, these are both unitary rights that are achieved by registration. So they effectively treat the European Union as one jurisdiction, and a single application in either case will secure protection across that whole jurisdiction. So in terms of Brexit, the simple issue here is that on the 31st of December, up to and including the 31st of December 2020, applications for and registrations for European Union trademarks and registered community designs had effect in the United Kingdom, and on the 1st of January, they didn't. From the 1st of January, they have not, I should say. So that change was a very specific change that happened on the 1st of January this year. And that obviously leaves a number of important questions open about what happens to the rights that were European Union rights, but where the European Union has itself now changed by virtue of the UK leaving. And I'm going to talk primarily about EUTMs. Then I'm going to just, but I'm going to say at this stage that in substantive terms, the changes in relation to RCDs, that's to say registered community designs, are in all substantive ways the same. So in other words, the mechanisms which I'm going to talk about with reference to EUTMs broadly apply in exactly the same way as they do for designs. So taking EUTMs, I'd like to divide those into two categories. And this is all about what the status of the EUTM was on the 31st of December, i.e. the last day that the UK was a member of the European Union. The first category is where on that date, you as rights holders own an EUTM registration. It was registered and in force on the 31st of December. Now, in that situation, the UK IPO decided that it was going to create this isn't an official name, but we refer to it as a clone of every single existing EUTM registration, which is on the EUTM register. And the UK IPO creates these cloned registrations on the UK register. That process happened in the first few days of 2021. And the effect of it is that for every EUTM registration, there is now sitting on the UK register an exactly corresponding UK registration. Now, the formal name these UK registrations are given is that they're called UK Comparable Trademark Registrations, or UK CTMs. And UK CTMs are identical to the parent, we can call it the parent EUTM, with the exception, obviously, of their geographical scope, and also with the exception of the official number that right holds. Although, in actual fact, what the UK IPO has done is simply to add the prefix UK 009 to all EUTM numbers. So essentially, they bear the same official number, but with the prefix UK009 on the front. Now, importantly, the status of the UK CTM is a registration. So it is created as a registration from the day it's created. The UK CTM is identical to the parent EUTM, has the same filing date, the same priority date, the same renewal date, and all the details of the specification and so on are the same. So that process was, if you like, automatic for rights holders. No official fee was charged by the UK IPO in creating those comparable trademarks. And actually, as a firm, we render no charge for assisting rights holders to document and process and their new UK CTMs and to become the address for service for those UK CTMs at the UK office. So this forms a major part of the Brexit process, this automatic creation of cloned rights. And just one detail I would add as well is that in the case of an international registration under the Madrid Protocol, where that has an EU designation, that EU designation also, if that was in force on the 31st of December, that gives rise to a UK CTM in the same way as an EU trademark registration that is not obtained under the international system. But that's slightly counterintuitive. You might have expected a UK designation within the IR to have been created, but in actual fact, an EU designation under the international system generates a UK CTM in the same way as all other EUTMs. Can we go on to the next slide, please? So the second category of trademarks I'd like to talk about are those where there is an EUTM which was pending on the 1st of January 2021. Now, in the case of pending EUT applications, there is no automatic cloning of new rights. However, the applicant of that EUTM has the option to request at the UK IPO that effectively a cloned UK application is created to reflect the EU parent. And there is a 9-month period which expires the end of September before the 1st of October. So the 30th of September 2021 is the deadline by which those UK CTM applications must be requested. As with the UK CTM registrations, these applications have to be for the same mark. They have to be requested at the UK IPO, as I say, by the EU applicant. They must be for the same mark. They must be in the name of the same applicant as the EU mark. And they must cover goods and services, either which are identical to those in the EU mark or which are contained within the specification on the EU mark. In this case, fees are payable. So the UK IPO will render the same official fees as it does for a normal UK application. And in our case, as a firm, we offer service charges which are similar. I think they're slightly lower, but broadly in the same ballpark as our service charge for filing a regular application. And that's because the process around a UK CTM application is essentially the same as it is for a normal application. It has to proceed through the examination stage. It's published for opposition purposes and so on. Again, for EU designations within the international system that are pending on the 1st of January, again, they give rise to a right to file a UK CTM application. They don't generate a designation of a UK mark under the international system. So that distinction is the same as I flagged in relation to the UK CTM registrations. So the key point here is that you need to have the 9-month deadline on your radar in terms of next steps. The issue about whether you can file for that UK CTM application depends simply on whether the EUTM was pending on the 1st of January 2021. So even if the EUTM was itself later refused, say in March 2021, you could still in May, June, July, August 2021 apply for a UK CTM application, because on the 1st of January, the EUTM was pending. Can we have the next slide, please? So this is just a chart which shows in a graphic way the timelines. The top half of the slide shows the timelines for the cloning of EU trademark or design registrations. So you'll see that the cloning has already taken place on the 1st of January, on or shortly after the 1st of January 2021. So no action is required by the proprietor in order to to generate those rights. The bottom half of the screen reflects the situation on pending applications, where the proprietor must file the clone in the UK by 30th of September 2021. That's the timeline. I would just make one point here, that this is really 90% plus about EU trademarks and corresponding trademarks in the UK rather than designs. And the reason for that is that RCDs, registered community designs, are examined very quickly. There's no substantive examination. They progress from filing to registration in a short time. Nearly all go straight through unless there are issues with the representations of the design. And so essentially at any given time, including on the material date here, which is 31st of December 2020, there's a relatively small number of RCDs which are in fact pending. And that is categorically not the case for EUTMs, which can be opposed. They can remain pending for many years if they go through an opposition process and then go up the appeal structure. So that's just a point worth noting. Okay, can we have the next slide, please? The next thing I'd like to talk about is the question of the renewals of EUTMs. Now, there are 3 basic points to make here, reflected in the 3 bullet points on this slide. And it's really all to do with when the EUTM in question is due for renewal. So for those EUTMs that were due for renewal before or up to the 31st of December 2020, when that renewal is effected, the corresponding UK CTM, which of course was created after the renewal date of the EUTM, the UK CTM will also be automatically renewed if the EUTM is renewed. And that applies, of course, even if the EUTM is renewed within 6 months of the deadline. So let's say there was a deadline of 15th of December and the 15th of December 2020 EU renewal date, and that EUTM was renewed in, say, April 2021. Well, then at that point, the UK CTM will be automatically renewed. So that's the first category of renewals. The second category is where the EUTM registration is due for renewal on or after 1st of January 2021. And in this situation, if you think about it, it's logical, because after that date, the UK is no longer in the EU. So after that date, the EU right and the UK CTM are separate rights. So in that situation, the EUTM and the UK CTM must be renewed separately. And one question we've had from a number of people is would there have been any advantage, it's now past of course, in paying the EUTM renewal fee early, i.e. in December or whatever? And the answer is no. That wouldn't avoid the need to pay the renewal fee on the UK CTM. So EUTMs due for renewal after 1st of January 2021 need to also be renewed in the UK separately in respect of the UK CTMs. And the third point on the bullet on the screen is just worth mentioning that EUTMs, I'm talking here about EUTMs that are due for renewal in the first 6 months of 2021. Here, the renewal fees for the corresponding UK marks can be paid up to 6 months after the EU renewal date without incurring late fees. So this is a decision that the UK office made to give businesses a little bit of margin for error, a little bit of a break in terms of not having to pay the fees if they missed that renewal date at the time it should originally have been paid. So could we go to the next slide, please? I've got a couple of charts here showing a timeline on those two main categories of renewals. So if you look here, if you imagine in this first slide a renewal date prior to 31st of December 2020. So let's say we have an EUTM that was due and renewed on the 15th of December 2020. Then on the 1st of January, the corresponding UK CTM was created. That UK CTM is in force and does not need to be renewed until the 15th of December 2030. So that renewal is automatic because the EU was renewed against a renewal date before 31st of December. Can we just go to the next slide? This is a second category, an example where the timeline obviously again goes from left to right. Let's say we have an EUTM that is due for renewal on the 30th of January 2021. Well, the UK CTM was created on the 1st of January 2021, and that has a renewal date of the 30th of January 2021, but it's a separate renewal. So basically the proprietor of these registrations has the choice of either renewing the EUTM or the UK CTM or both. And there's no advantage, as I said a moment ago, in renewing the EUTM before the 31st of December. I've also mentioned here that, of course, the UK CTM in this example could be renewed up to the 30th of July 2021. In other words, the first 6 months after the renewal date with no fee penalty. So next slide, please, Adrian. Thank you. So what I've talked about up to now is the question of transitioning from pre-Brexit to post-Brexit. But now, since 1st of January 2021, we are, of course, in this new post-Brexit world that we're getting used to in the UK. It's actually a great relief, as Adrian said, to have all the debate about the, all the arguments around Brexit are out the way now. We actually know where we stand, whether we agreed with it or not. This is where we are now. And actually, there are plenty of opportunities this side of the fence. But the key thing I'd like to stress here is that, of course, now and going forward indefinitely, the UK and the EU are separate jurisdictions. And what that means is that brand or business owners that have commercial interests in the UK and EU will need to file separately in those two jurisdictions. And that applies both for EU trademarks, sorry, that applies both for trademarks and for designs. I would just mention in passing that the word potential commercial interests is important here because both the UK and the EU are so-called first to file jurisdictions. That's to say the rights in the trademark rights in a mark or sign go with the first party to file an application rather than the first party to use a trademark. Now that position can be overturned in favor of a first user, but the hurdle is high. In order to achieve that, in order that first use prevails over first application, requires either a passing off right, which is a high burden evidentially to prove, or as a result of bad faith on the part of the applicant of the trademark application. So in first to file jurisdictions, it is always a good idea to cover not only those goods and services that you are using already in the jurisdiction in question, but also that you take sensible steps to protect, have a radius of protection around those goods and services which cover what you might reasonably do as a business in the foreseeable future. And I would say that it is a much safer approach to, obviously subject to budgetary requirements permitting, to register in both jurisdictions, if there is any interest, even in a medium term, in one or other. Because once you have your application on file, you have a marker in the sand, your claim is on the public record, your claim to that trademark as of that date. And that is then it is then for third parties to, to say that you shouldn't have that position, but the default position is that you do. So that's a strong position to be in. So next slide, please. So as I said at the beginning of my section, I have focused very heavily on trademarks, not least because the numbers involved are very much greater for trademarks than they are for designs. That's not to say designs are not important, of course, but also coupled with that is the fact that the position on registered community designs is exactly the same as on EU trademarks. That's to say there are different procedures for those RCDs that are registered on 31st of December and those that are pending. But as I said earlier, there are, relatively speaking, a very small number of pending community designs, relatively speaking, which means that, to all intents and purposes, that a very large proportion of RCDs were transitioned across by virtue of the automatic cloning that happens for registered rights. So next slide, please. So I'm going to just finish my section with 3 slides which address some areas to be aware of in connection with inter partes matters. That's to say oppositions between parties or invalidity actions between parties, invalidity and cancellation actions. Now, just to take the question of pending oppositions first. So after the 31st of December, I'd like to consider pending opposition cases in 2 situations. Number 1, where that pending opposition is at the UK IPO. So that means that there is a UK application that has been filed by company A or individual A that has been opposed by, we'll say in this example, by an opponent who is relying on an earlier conflicting EUTM. And the key question here is, what was the filing date of the opposed application? So if the filing date of that application was before the 31st of December 2020, then that means that the UK IPO is likely to refuse the UK TM application. This is assuming, of course, that the trademarks are similar and that the grounds of opposition are good. But in that situation, the UK IPO is likely to refuse the UK TM application on the basis of an EU TM. That decision will be dated in 2021 or later. But that applies because at the material date in the opposition, that's to say the filing date of the opposed application, the UK was still in the EU, and therefore an EU trademark is a valid basis for opposing that UK mark. So in that situation, it may seem counterintuitive that after Brexit, a UK trademark could be rejected in an opposition where the only ground of opposition is an EU trademark, and yet we've left the EU. So I'm just saying that there is a situation as outlined in number 1 there, where that would not be the case. The second situation, if we consider it the other way around, we have an opposition at the EU IPO, where there is an EU TM application which has been opposed. We assume that application has a filing date before 31st of December, as in the first example, But in this case, the opponent is relying on an earlier conflicting UK trademark. Now, in this situation, again, this is the other way around, and this is because the rules at the EU IPO are different from at the UK office. The UK IPO is likely to accept the EU TM for registration because the earlier UK trademark was a valid, whilst it was a valid ground of opposition at the time the contested application was filed, it was not a valid basis at the time of the EU IPO decision, because that decision would be in 2021. So in that situation, the EU IPO is likely to accept the EU TM in question. Right, so next slide, please. This is a slightly simpler slide. This is just where we have pending cancellation actions at the EU office that are pending on 31st of December 2020. Then a later decision to cancel that EU TM registration, later in the sense that it occurs in 2021 or after, will also apply to the cloned UK mark. That cloned UK mark will be similarly cancelled if the EUTM is cancelled. The only exception to that is if the grounds of cancellation do not apply in the UK. Now, at the EU IPO, you could have a European Union trademark application that is opposed based on a French registration or a German registration, but not a UK registration. In that situation, the UK CTM would be secure. Next slide, please. And finally, just a word about non-use cancellation actions, because this is also quite important. So here we're looking at revocation actions for non-use being brought against, firstly, an EU TM. So from the 1st of January 2021. So a party comes along now and seeks to cancel a European Union trademark for non-use. The proprietor of that EUTM will be entitled to rely on use of the mark made in the UK before Brexit. And that's because the UK was in the EU at the time. Of course, that stands to reason because non-use periods, as many of you will know, are 5 years. So when someone challenges a registration for non-use, you have to look at the past 5 years, and the owner of the registration has to prove use in order to maintain its registration. Well, if you go back from today for 5 years, then only 2 months of that 5-year period is after Brexit. The other 4 years and 10 months is when the UK was in the European Union, and therefore for all of that time, it's logical that the use made of the mark in the UK should support that European Union trademark. But clearly going forward, that will diminish. So over the next 5 years, that will diminish and then disappear. And then the other way around, if you have a revocation action brought at the UK office against a UK CTM, the proprietor of that UK CTM, again, can rely on use made of the mark in other parts of the EU prior to 31st of December, prior to Brexit. And of course, that is a slightly odd situation. It means the owner of a UK CTM can successfully defend a non-use action by relying only on use in, for example, France or Germany or Italy, even though it's a UK-only action. Again, the principle of why that is the same as I mentioned a moment ago. It's all to do with when Brexit happened and the fact that you're looking at a 5-year period for non-use. So I thought those 3 areas are worth mentioning just as a word of caution that Brexit has raised issues in connection with contentious proceedings that need to be carefully analysed, and obviously with someone in the UK or EU to help you through that process. But I thought it would be helpful to share those thoughts with you. So with that, I'm going to hand back to you, Adrian.
Thanks, Jonathan. So the next topic deals with EU domain names. I think this is relatively small interest for the present audience, but nevertheless, I'll go over it very quickly. So if you had a .eu domain name, that can only be owned by an EU citizen independently of their place of residence. So UK businesses will no longer comply with those requirements, but EU citizens residing in the UK will still comply. Unregistered design rights. So Jonathan has talked in detail about registered design rights, but there are a number of parallel systems of unregistered design right. So there is UK unregistered design right, which is intended to protect things like industrial designs, so the shape and configuration of parts of manufactured items. The nationality and residence requirements for the designer to qualify, which currently include the UK and EU persons and businesses. So after Brexit Day, which was 1st of January this year, EU businesses no longer meet the criteria and may own the UK unregistered design rights may only be owned by UK businesses or a relatively short list of countries that offer comparable rights. There was a system, there still is a system of unregistered community design rights, which is a short-lasting right from 3 years of disclosure of a novel design having individual character. And in common with the rights that Jonathan has discussed, the UK has established a continuing unregistered design right to provide runoff protection for those rights in the UK. So really the unregistered community design right was for things like clothing manufacturers and items and industries having a very high turnover of designs. And the UK has introduced its own parallel regime covering essentially the same type of subject matter after Brexit Day. So I probably won't dwell too much on this, but it relates in particular to where a design is first disclosed. The practicalities, as Jonathan has mentioned, the UK IPO has generated a parallel rights for UK community trademarks, and these are reflected in the register, and they have been given their own number. Now, a topic that is relevant to patent owners is the doctrine of exhaustion. So whilst the UK was a member of the European Union, there was a doctrine of EU exhaustion. So a first sale anywhere in the EU was said to exhaust the IP owner's rights, and the IP rights owner could not then use those rights to prevent distribution of the patented product anywhere else within the EU. So this was particularly relevant in, for example, pharmaceutical industry, where the retail price of certain products tended to be much lower in Eastern European markets, and these were parallel imported back into other EU territories. So the system after Brexit, the EU will not recognise as exhausted in its territory goods protected by a patent which are first placed on the UK market with the patent owner's consent. So what that means is if you first sell a patented product in the UK, then you can potentially use your patent rights to prevent parallel imports from the UK into the EU of that product. However, the converse is not true. So if you first sell a patented product in France or Germany, for example, you cannot use your UK rights to prevent parallel import into the UK. So IP rights in goods placed on the EEA market, so that's the EU plus a couple of other countries, will be considered exhausted in the UK. A rather specialized topic which is applicable in the pharmaceutical sector. The EU marketing authorizations, so this covers supplementary protection certificates, which are a right which confers an extra term of protection on pharmaceutical products which have had to undergo a regulatory approval process. So this was a piece of EU legislation. And without getting too much into detail about pharmaceutical regulatory approval in the EU and the UK, after the 1st of January this year, you will need a United Kingdom marketing authorization in order to obtain a supplementary protection certificate. So previously, most pharmaceuticals in the EU were approved via the European Medicines Authority. And there are a couple of other subtle points about things like pediatric extensions, and if anyone is interested in those, I'll be happy to discuss that offline. Plant variety rights. So there has existed parallel schemes in the UK and EU for registering of plant varieties. And obviously after the 1st of January this year, that you will no longer be able to obtain a plant variety right protection in the UK via the EU office, and you must apply separately to the Animal and Plant Health Agency in the UK. Pending applications, which were pending on 31st of December last year, will automatically be converted into parallel applications in the UK. So just to recap on what Jonathan and I were saying, the next steps. So proprietors of EU trademarks, you need to consider whether to opt out of your clone, but your parallel right will be generated automatically. Jonathan, please feel free to chime in if I'm saying anything that's incorrect. There's the 9-month period, which Jonathan mentioned, expiring in September. Is that correct?
That's correct.
Yeah. If you are a business which is doing trade in the UK and one or other EU member states, you need to consider the implications of exhaustion of your rights when you're moving goods around the UK. And if you're a rights owner, you can consider whether to use your rights to address issues of parallel importation. So EU domain name owners consider whether it's possible to transfer to an entity entitled to hold that name. Specific industries, such as the fashion industry, consider where to disclose your design for the first time if you're relying on unregistered design right protection, or consider registration. We haven't talked about geographical indications, but the UK has introduced its own system. Is that correct, Jonathan? It's outside of my area.
Yes, it has. And there are, I mean, I think it's probably something that we haven't got time to go into very much now. But yeah, there are various transitional provisions in relation to GIs.
Yeah, yeah. And for all businesses, in particular with regard to design and trademark filing, you need to adapt your IP strategy to reflect the fact that the UK is now an independent jurisdiction, and you need to address that when you are planning to make, in particular, trademark and design filings. Of course, we can help in many of these areas. If you have concerns regarding your patent estate, we'd be happy to advise on that. And Jonathan, do you just want to talk for a couple of minutes about our particular offering on the trademark side?
Absolutely. Thanks, Adrian. Yeah, just to finish, there are a number of ways that we can potentially be of assistance to you. One is by helping to manage the process around you or your clients' UK CTMs, including assuming responsibility for these. In other words, becoming address for service at the UK IPO, which then means we have those registrations on our records for the purposes of future renewals. We would also hear very quickly if anything happened to that registration in between renewals. For example, if a third party filed a cancellation action or something of that nature, we'd be in place there and would be able to send you that very quickly after it happened. And there's no charge for that first bullet point, as I said earlier. The second area is the whole business around UK CTM applications, these applications which owners have a right to file within 9 months of Brexit Day. And we can advise you around those, whether it's that we can advise you on the timing of those applications in a given case. We can, of course, then handle the preparation and filing of those applications to make sure they are filed with appropriate parameters to qualify as the UK CTM applications that you want them to be. So that's another area. I mean, this is the third one's arguably the one that's most important going forward, because now that we are out of the EU, as Adrian said, businesses need to be thinking about the EU and the UK as separate jurisdictions going forward, and evaluating what types of IP they need in both of those jurisdictions. We have got a competitive offering for businesses that wish to file simultaneously for the same mark in the UK and EU, because we foresee that this is an area that many businesses may want to do. So we're making that as competitive as we can. And then fourthly, we are obviously at your disposal for the purposes of renewing EUTMs and navigating through any renewal issues that arise in relation to UK CTMs. As I said earlier, there are several situations there that differ slightly because of the timeline from normal renewals. And of course, I haven't spoken a great deal about registered designs, but as I've said a couple of times, the whole registered design framework with Brexit is extremely similar, virtually the same, in fact, in all substantive respects to how it is for trademarks. And so as a firm, we're well placed to assist you on any parallel matters that might arise in relation to registered designs. Thank you.
Fantastic. Absolutely clear. Thank you very much, Jonathan. Excellent flow. Thanks, Adrian. I think it was a much needed clarity. In fact, I thought that patents were not equally, but at least affected to quite a bit as by virtue of this. But by the amount of time that Jonathan spoke for as regards trademarks is concerned, indicates that patent doesn't really get impacted that much. But anything on the patent side that otherwise, Adrian, that clients should be careful on? I do understand at this moment, EPO doesn't get impacted at all, and aspects of that nature. But from a future perspective, from a cost perspective, any input that you would have that clients should sort of keep in mind for new applications that they're intending to file at the EPO? Anything at all that you think can be a good strategy or something that they should think about?
Well, I think in terms of strategic considerations, it's exactly the same as it was before. So the European patent is good if you're looking for protection in 5 or more countries. For 3 countries or fewer, you're probably better off going for national patents. So I think that calculus hasn't really been affected too much. I think it's only in specific industries where it really has an impact. So in pharmaceuticals, it has a significant impact because of these parallel import and supplementary protection issues. But no, I mean, if clients need us to assist in decisions on whether to go for a European patent or national patents, we've got some tools that can help with that evaluation.
Absolutely. There's a question from Maitri. It's about what is the position as regards the EU switching to the unitary patent system, and I understand that will enable any party to obtain a single patent effective in all EU member states. Could you throw some light on that, Adrian?
Yeah, I think that system is more or less dead now. So it really only made sense when you had the 3 main patenting jurisdictions, namely the UK, France, and Germany, in the system. And from what I've heard, the latest is that the system well, the UK definitely won't be going ahead in that system. And I think without the UK as part of that system, it doesn't really make a lot of sense. So I think that's history.
And Jonathan, from a trademark perspective, obviously, because a lot of clients do a lot of searches, registrability searches before they even file applications, and if they do or are aware of the fact that there is an entity sitting in France, for example, that has a brand which is sort of deceptively similar or is quite overlapping with what they intend to file, would they be better off than only filing it in the UK? If they're obviously commercially they had to sort of cover the whole of Europe, but would it make more sense for them to start with the UK, at least get a provisional, get a protection there, and then file it in the EU IPO, or would it not sort of matter too much as regards the timing of filing is concerned?
Yeah, that's a good question, Taryn. I mean, I think it like a lot of strategy questions, in the final analysis, it comes down to the priorities, the commercial priorities of the business in question. So I can imagine a situation that you've described where it would indeed make sense to file in the UK first, because the third party that's been identified does not have rights in the UK. That could form the first foothold in what we now have to call the EU/UK. But in other situations, I mean, it's worth remembering that for 20 plus years, we have been operating in an EU trademark system where there are many hundreds of identical and similar marks sitting on the register together, for the simple reason that the EU IPO, and indeed the UK IPO now for many years, does not actually formally examine against prior rights. And the reason for that, clearly with the EUTM, is that if you examined against prior rights, given that a national trademark in, say, Slovenia could be a valid prior, you would never get anything registered. It would be a total disaster. And they decided that right in the beginning. So we as practitioners are very used to running searches across the EU, and there is never a complete absence of similar marks. So we have to be quite pragmatic in that. And we have to essentially, I mean, I think my advice strategically would be to be ahead of the curve on when you apply in Europe for this reason. The way that would play out would be that if you have your EU and UK applications filed significantly before you actually launch, then you're not taking very much risk. What you're risking is the fate of your application. But if you go with an all singing, all dancing launch at the same time as on the same day as you file an application, that's much more risky, because then if there was an aggressive third party out there, they could be looking for injunctions and court cases, which is highly undesirable. So I think we always encourage clients, because of this first to file system, to file applications early. And if you can work into the timeline, I know I'm talking about this from a trademark advisor's perfect scenario, and I know you guys in the front at the sharp end of business will say to me, yes, it's not a perfect world. We have many things to weigh up. But I'm just saying from an IP perspective, it is undoubtedly better significantly better to put as many months as you can between filing the applications in Europe and actually launching. And that, I think, is a good way of reducing risk. Because in the example you gave, if there's a French trademark owner for a deceptively similar mark, well, the application process is likely to flush out whether that party has an issue. And it's much better that that is flushed out in the context of an EU IPO opposition than it is in the courts.
Absolutely. And then one final question, unless anybody else has, I'll just open it up. One final question was about the applicability of precedents for the EU IPO. So decisions coming out of the EU IPO, will they be citable by UK trademark attorneys and UK applications as to not only not only on family applications where, for example, there was an opposition filed in the EU IPO and the corresponding opposition was also filed in the UK, and then the applicant actually won that particular case. Can he just go ahead and use that as a case law essentially to apply to the other side?
I think, Taryn, it won't be. I think the short answer is that they won't have the force of formal precedent. However, the fact is that the UK and EU and the EU have had highly harmonized trademark and design systems for 20 plus years. That is not going to change overnight. What I think will happen over the next 5 years or more is that the jurisdictions will diverge in terms of their precedent gradually. And on many issues, they will stay harmonized. I don't think the courts are going to artificially cause separation, but I think at the same time, it won't really be possible to claim formal precedent in that way.
Understood. I'll open it up for 10 seconds. Anybody has a question, feel free to ask it through the audio or through the chat box. Otherwise, I'll give the word of thanks. I think we're good to go. Fantastic. Adrian, thank you very much for accommodating me and on a short time basis, and thanks for accommodating us and sparing our time, valuable time on this issue on a Friday morning. Thanks, Jonathan. An absolute pleasure. Thank you very, very much. And I have the email addresses and coordinates, and anybody who's a part of the call who wants to get connected with Adrian or with Jonathan directly, very happy to share that. And then look forward to many more to come. Thank you again, guys, for the time. And thank you, everyone, for joining in as well.
Thank you, Darren.
Thank you very much for the opportunity. I've enjoyed it very, very much.
Likewise.
Thank you.
Thank you.
Thank you, everybody.
Bye-bye, everybody.
Bye-bye.
Thank you, guys. Bye-bye.